So I will be refuting my opponent's claim that the right to marry is inalienable and it is biased to deny this right based on sexual orientation. I'll be supporting my refutation by responding to my opponent's three secondary claims, which are: 1, that outlawing same-sex marriage further limits the civil liberty of equality for homosexuals; 2, gay marriage is an inalienable right which should not be subject to majority vote; and 3, Proposition 8 is a part of the bid for equality of law. I will do so by using the methods of challenges to evidence and challenges to reasoning. My opponent's first claim stated that outlawing same-sex marriage further limits the civil liberty of equality for homosexuals. She gave 3 supporting statements that resulted with the reasoning that because homosexual couples cannot, under the laws of California, be deemed married, they are denied the right of equality. This is a hasty generalization made in lack of evidence, based on a claim of value rather than fact. The evidence provided by my opponent stated that the Equal Protection Clause of the 14th Amendment prohibits any state from denying any person equal protection of the laws. Well, according to the Article 1 of the California State Constitution, the law clearly states that marriage is defined as a joint relationship between a man and a woman. Therefore, no person, gay or straight, is denied equal protection of the laws under the 14th Amendment. The claim of value that this is unfair, or as my opponent stated, unequal treatment, is not relevant to this claim of fact speech. The advocate's second claim that gay marriage is an inalienable right but should not be subject to majority vote. This is a claim of policy, once again, not a claim of fact. Further, the evidence used to support this policy was inefficient and irrelevant. The first statement of evidence was that in May of 2008, it was decided that same-sex marriage was permissible. According to FindLaw.com, May 15, 2008, the Supreme Court ruled that limiting marriage to persons of the opposite sex violates the California Constitution, and it wasn't really until June of 2008 that it was decided that gay marriage was legalized in California or permissible. Although it's only a slight inconsistency, it makes the mind wander to what other inconsistencies could remain in the advocate's argument. Another piece of evidence used to support the advocate's second secondary claim was a quote from an unrecognized so-called expert. It was never explained by the advocate the expertise of the speaker. The quote was by Ms. Kelly Rivera Hart, who stated, "There is never a time when it's for the majority to decide the rights of a minority. This is only a matter of opinion, unbacked by statistical or even factual data." The final supporting claim made by the advocate was that Proposition 8 is a part of the bid for equality of law. This ambiguous statement is awkwardly stated and almost sounds as if the passage of Proposition 8 was a step towards equality, which in itself refutes the entire argument made by the opponent. The evidence used to back this final supporting claim was once again insufficient. The first evidence was that same-sex marriages that did take place were a step in the direction of equality. This is once again not a claim of fact, but a claim of value. The opinion of whether or not a step was made in either direction is irrelevant in a claim of fact speech. The rest of the evidence used in the last supporting claim was also dismissible. The statement made that Proposition 8 was a part of one of the largest struggles for equality in decades uses emotionally charged language, which weakens the argument and lessens the credibility of the speaker. The final evidence given, attempting to conclude the claim of fact speech, was that in California there is talk of removing the term married for all couples, gay or straight. This is only hearsay. The fact that this statement was said to happen, or whether it will ever happen, is irrelevant. In conclusion, the advocate failed to prove the stated claim of fact. Looking back upon all the supporting claims and evidence given, the advocate clearly failed to prove that the right to marry is inalienable, or it is biased to deny this right. In our opening statement, as I have shown, irrelevant, inadequate evidence led to holes in the reasoning of the advocate, leading to the overall ineffectiveness of the speech.
All right, the secondary claims are listed pretty clearly. You signpost as you go through. There are a lot of challenges that you're making to the arguments. I think sometimes you need to specify the advocate's evidence a little bit more. I thought on the first point where you make reference to California's Article 1 defining the nature of marriage, that was pretty good. You do assert that there's a value claim at the basis of most of these arguments, and I think you need to explain a little bit why it is a value claim. What is the inference that is being made here by the advocate that is value-based and why it's not fact-based. On the second point, again, a good clear signpost. You say it's a policy claim in this particular case. I've run into the same question here. What makes it a policy claim? I'm not saying that it isn't, but there's no explanation about why it's a policy claim and not a claim of fact. You get in a little sidetracked on this issue about the dates in 2008, and I'm not exactly sure what it gets you in the long run. The notion about rights and not being able to, we shouldn't be able to vote away somebody's rights, or it shouldn't be subject to majority. I thought that you had a reasonable press on that's just an opinion. I think one of the things that you might do is give us some comparative illustrations of exactly how such things have been determined in the past, specifically about issues like that. On the third point, it's a little confusing. It seems to be that you're suggesting that it actually is contradictory, but it wasn't clear to me how you were making that inference. We're back to the value argument again. I thought you explained that a little bit more clearly. The dismissal of the argument about getting rid of any reference to marriage as hearsay, I thought that was a reasonable press on that point. You need to look up at the audience a little bit more. You're reading, and there's not much variation in your tone when you're delivering the argument, so it sounds a little dry and dull. All right, thank you.